Just give me your reaction to hearing the guilty verdict on that charge of manslaughter this afternoon.
Well, I think the jury's sending a very clear message that, there's a fine line between self-defense and the illegal use of deadly force. And in this case, I think they sent the message that deadly force was not justified, that perhaps Ms. Lawrence could have waited for law enforcement, and that deadly force, it's an option that needs to be used only when necessary.
And that really was a big part of this. Obviously, no one ever contested that Lawrence fired that shot that killed A.J. Owens, her neighbor. But that was the question all along, was the defense trying to argue that it was in self-defense, that she was afraid for her life, and the prosecution saying she wasn't afraid, she was just angry.
I agree. And again, this happens, it happens usually, the old days, there's no duty to retreat. Well, there's never been a duty to retreat in your house or duty to retreat outside. Now we have something that, it's the threat is outside your house. And I think this sends a message out that, you can't just use a firearm, especially when you're safe inside your house. Perhaps if that door would have opened, perhaps the jury would have come back with a different decision.
I'd like to get your thoughts on this is something that is always interesting to think about, and it's something that the judge always tells the jury not to put any thought into or any stock into, whether or not the defendant testifies on their own behalf. And Susan Lawrence in this case did not testify on her own behalf. Can you talk us through, as a defense attorney yourself, the strategy on when it may be advisable for a defendant to testify in their own behalf, and when, as in this case, we did not see that?
I mean, as defense attorneys, we usually don't like to put our clients in to testify. That opens the door for cross-examination. And sometimes, there's this thing that says, don't ask a question you don't know the answer to. So, again, there's a presumption in our Constitution that everyone is presumed innocent. And the burden of proof is on the state to prove that you've committed every crime or every element of the crime beyond a reasonable doubt. So it's not necessary to take the stand. I think here, when we have the standard of, it's a reasonable person must believe that there's an imminent threat, I think everybody in the jury can relate to that. They can put themselves in the shoes of the accused in this case, and they can determine whether they're a reasonable person and whether there was imminent threat. I'm not sure that's any testimony that the defendant would have made at this time on the stand would have been a greater benefit than a greater harm of exposure to cross-examination.
The jury really only deliberated for about 2.5 hours in this case. Can you give us a little perspective on what that wait is like in that time between the jury kind of retiring to begin those deliberations and the jury coming back with a verdict rather quickly in a case like this?
I agree. It's got to be very quick. Sometimes quick verdicts by a jury can say either way, whether it's guilty or not guilty. I think in this case, to be able to convince 6 people of this kind of manslaughter by a firearm case, I think they thought the evidence was pretty overwhelming, and that's why they came back with a guilty verdict. A lot of times, they have to look at a lot of, there's one person that perhaps is inclined to not agree with the rest of the group. That could take hours to convince. But I think the fact that they came back pretty quickly, and again, I think this is something that a lot of people can relate to. A firearm being in your house, neighborhood dispute. And again, it goes back to a reasonable person. We're not talking here about DNA evidence. We're not talking here about identity or credibility. We're talking a reasonable person. And what would you have done in that position? I think that's easy sometimes jury to achieve at a decision when they can put themselves in circumstances that, it's common for all of us to relate to.
The charge in this case was manslaughter. Florida statute does have kind of a differentiation for manslaughter with a firearm, and that was one of the things we heard in that verdict being read out was this crime committed with a firearm or something along those lines. Can you talk us through what the possible penalties are for that? Because my understanding is that manslaughter with a firearm is a higher degree of a felony than just a standard manslaughter charge.
It is. It's a first-degree felony, which judge could sentence her up to 30 years in prison. Now we're going to go into the sentencing stage, and the defense is going to be able to put forth some evidence, some mitigation, in particular in this case where she was under medication. The circumstances that rose to her having this kind of fear. And so there's going to be a lot of mitigation. It's going to take, this will be presented to the court, and the judge will make a determination. But yes, it's a first-degree felony, punishable up to 30 years. Again, she's 60 years old. So, a 30-year sentence is kind of like a life sentence, and especially when you're incarcerated at that age. So that's something that the judge will take into consideration. Again, we remember, that the jury makes determination of guilt, and it's the judge who's going to impose a sentence which he feels is appropriate under the circumstances.
If you are the defense attorney in this case, what are you now trying to do to lessen that sentence as much as possible for your client? What happens now? Take us kind of behind the curtain.
We go into what we call mitigation. Mitigation is we will bring in witnesses that will pretty much testify as to her health, for example. Does she have any kind of medical conditions? Is there any other alternative ways, perhaps a short prison sentence followed by some kind of community control or what we call house arrest? I think the first step is to try to get her bond while we wait for sentencing. And at this case, you can see the judge already denied it. There's going to be what we call a PSI, which is pre-sentencing investigation, where they're going to do a report on her history. It's what we call a rap sheet. And it's going to pretty much say her history, or her parents, any kind of history and involvement, any kind of criminal history. And those are all things that we will present to the court at sentencing. We will bring in her family to testify. Now, at sentencing, both parties are going to be able to bring witnesses. So the victims of the family of the victims are going to come in. They're going to testify and say how this has impacted their lives. But also the family of those are accused of Ms. Lawrence. In this case, they're going to present medical conditions, any kind of mitigation. Perhaps I believe she was under medication. Her fear and what rose to this level and why it occurred. It's a way to tell the court, yes, we respect the decision of the jury, but we feel that the sentence should be less sentencing rather than more for the following reasons. And those would be some of the reasons: medical, her involvement in the community, her lack of criminal history, and her age, her medical conditions. Those are all things that would play into the sentencing.
What would you expect to see as the sentence in this case? Do you think we're going to see something more toward that maximum of 30 years?
I would guess in the 15. I would guess in the 15 to 20 year range. That is correct, followed by some kind of probationary time period. But I don't think the judge will go under 10 years. Being in the consequence, the circumstances of this case. We have a family that have lost a family member. So I would, if I was to guess, I would be right around the 15 to. I don't think the judge would give her 30. I think 15 to 20 years old. I mean, sentencing would be appropriate.
Do you think some of those factors, like the fact that she is already almost 60 years old, do those kind of things you think would play into that in some ways?
Absolutely. Again, the age is something that, again, this is someone who's going to require some kind of medical care. There's also going to be someone who's has family members. And again, it could have gone both ways. Had the jury come back not guilty, she would have gone home. So we have, the issue of self-defense is something that Florida has, tickered with for the last several years. And in this case, I think there are other factors. The fact that this is a dispute that arose in a neighborhood. It's not a burglary. It's not a felony. You have your children. I think there's a message that's being sent out. I also think, not only her age, her family members, her engagement in the community. I think all of those will have a factor as to how the jury or the judge will sentence her.
All right. Well, Jose Rivas, criminal defense attorney, thank you so much for joining us here on Fox 35 News Plus this afternoon.